The asset protection, estate planning, business planning firm Barth Calderon. Thanks for jumping on Wealth Protector TV. Very fired up to have you. And we do this every week at 1 p.m. Tuesdays, California time zone. So stay in tune to us. The whole focus here is to deliver high value content to you that can help you in some way. And so today we have one of our top in-demand speakers across the country, attorney Brad Barth, and he is giving a presentation to an apartment association in California on asset protection. This applies to anybody owning rental income property anywhere across the country. And it's just an eye-opening discussion. Brad, as you'll see, is incredible, breaks it down, gets into the weeds, and gives you actionable tools and strategies you can use right now. And so also I want to mention that watch the whole program. At the end, we are going to give you an access to get one-on-one with Brad. If you have any questions on your own planning, invariably questions come up and people have things going on with their own planning, their own property, and Brad can't address everything in these live presentations. So we give you the opportunity to get one-on-one with Brad, complimentary, and we'll show you how to do that at the end of the presentation. So thank you. Let's go take a look and listen to Brad's talk.
All right, first of all, I just want to say thank everyone for taking the time out of your schedule to listen to the presentation. As Paul mentioned, we are an asset protection and estate planning firm, and one of the key areas that we work with within our clients' overall portfolio is dealing with their real estate investments. The substantial majority of our clients do have some form of overall real estate, and it's one of those assets that I say that are basically, it's two sides of one coin. Real estate is both an asset because it provides you with a source of income, tax deductions, it provides capital gain, and other forms of benefits. But at the same time, it's also an asset that presents a unique type of liability associated with it. Because unlike a bank account that would really never sue you, or a bond that would never sue you, real estate comes with certain risks associated with it. They have tenants. And many times tenants have friends, or they have activities on the land, and it could be a source of liability. And so although we can control a lot of the activities within our life, the things that we do, things that our spouses do, maybe if we have a business, we can kind of control our employees, we can control our product we put out in the stream of commerce. Sometimes we can't always control what's happening on our properties, especially when we're not there to supervise them. And so, especially in an environment like California, where you have a very tenant-friendly environment, the premises liability issues that are presented to our landlords, again, present quite a substantial liability that we always want to try to accommodate. So I'm going to share with you my screen to start going over some of the presentations. And I call this talk real estate. Let's go here. Let's see. There we go. Real estate risks and how to avoid them. I don't think any of the examples I'm going to give you are going to be anything new to you, but maybe some of the tools and techniques that we use to kind of insulate and isolate the assets from liabilities, I think may be new to you. As Paul had mentioned, my name is Brad. I'm a partner here at the firm of Barth Calderon. I myself have been doing this type of work for the last 21 years. I am a partner here. I deal with both the domestic as well as offshore asset protection, estate planning, estate administration, litigation, and things of that nature. So that's kind of a little bit about who I am. And just from an agenda for today, I want to speak a few minutes about what is asset protection, because some people don't quite understand what it is and why it's necessary. I think I kind of already addressed that issue and why it's necessary for real estate assets, because again, they present a unique form of liability that other assets don't present. We'll talk about some of the common forms of property ownership And then I want to deal with the quote I get quite often, either coming from clients of mine or from other advisors of clients of mine, saying that, a lot of this legal stuff that we do, maybe a lot of, creating a lot more tax work and maybe causing a lot more ongoing expenses. Really, all you need to do is just go out and buy more liability insurance. I'm going to address that issue a little bit later on, and why that may not be the sole method of an asset protection strategy for your properties. We'll talk about the use of LLCs and also trusts to hold your property. And then we'll speak about your residence. So we're talking about liability issues with property. We don't want to exclude your residence. Now, your residence, is highly unlikely that you're going to sue yourself. So we're not looking at the liability presented here so much as a slip and fall on your own property, but we're looking at your residence as one of your main assets. So although you may not sue yourself, maybe somebody else will sue you. And as a result of a lawsuit being presented to you, to what extent is your home protected from the claims of creditors, predators, liens, or judgment holders? So we'll speak a few minutes about that as well. But of course, if you have any questions, by all means, feel free to just raise your hand. Paul will call you out, and we'll kind of keep this as interactive as possible. And at the conclusion of the presentation, I believe Paul will go ahead and collect some of the attendee sheets so you can get on the counter with me to address any specific questions you may have in any of the areas that we'll be speaking about. Okay, so I think it's always important to start off with what a definition of asset protection is, because I think one of my biggest responsibilities as a lawyer with my client is simply to educate them as to what's the scope and breadth of what asset protection is, what it can do, and what it cannot do. You're not going to find really a definition of asset protection in Black's Law Dictionary, but because what it is, it's really it's a process by which we segregate assets from liabilities, and we do so by using other legally accepted concepts and strategies to make sure a person's wealth is not unjustly taken. And we're all familiar with forms of liability: homeowners policies, renters liability, general liability insurance policies. But we also want to couple that with structures. And here again, you guys are familiar with asset protection structures. There are certain forms of trusts. There's LLCs, there's corporations, there's limited partnerships. But when you bundle those all together in an estate planning environment, in a centralized management environment, in a retirement planning environment, in a education planning environment, you start kind of putting this big map together. That's what an asset protection plan is. It's not one thing. It's not, oh, I have a corporation, so I'm fine. Oh, I have an LLC, so I'm fine. It's kind of the totality of a cornucopia of tools that we use, again, to segregate assets from liabilities, to make sure that they're isolated and insulated from each other. And then what's in red down here below is really my definition. I just say the more barriers between assets and liabilities, the greater the leverage you have to negotiate a fast and favorable settlement with your creditors. And I like this because I think this truly is what asset protection is all about. It's all about leverage. In America, as you know, we are the most litigious country in the world. And I think here in California, we're probably the most litigious state in the country. And so we may not be able to prevent you from getting sued because we are kind of a sue-friendly environment. But what we can do is we can insulate those assets to be able to protect them from the claims of those creditors if a lawsuit does arise. So this is where leverage is all about. It's not about making you lawsuit proof. Hopefully it's making you collection proof, thereby putting you in a better position to negotiate a fast and favorable settlement with your creditors. It's very simple. If you're not the low-hanging fruit and they have to work extra hard to get your assets, then you're going to be in a better position to negotiate a fast and favorable settlement. Take the insurance and run away and leave the rest of my assets alone. That is truly what asset protection is. And I already mentioned some of the risks that real estate owners face. There could be slip and falls, there could be fires. And I have, over the years of doing this type of work, every one of these I have real fact patterns for. Slip and falls, I've had people that passed away in fires. We have slumlord scenarios. I got dog bites. We have electrocutions. We got lead paint. We're actually working with a couple of cases up in Northern California right now where maybe it's not lead paint, it's the mold. The mold is the new lead paint. So it's all of these different types of liabilities that are being presented. To what's happening is our clients are getting blindsided. They simply rent a piece of property out, and next thing I know, they're getting sued because of a mold problem, or the neighbor dog bites them, or there's a bad lighting and they fall down the stairs. Next thing you know, they're stuck with a multi-million-dollar liability, and then they're hoping and praying that the liability insurance coverage is going to cover them, or they're not going to adjust it down to a point where they wind up owning part of that liability. As I mentioned here again, simply appreciating that unlike other assets, real estate has risks associated with it. Appreciate it, acknowledge it, and simply just do what's necessary to protect yourself. It's a great form of investment. That's not the issue. It's a matter of acknowledging the certain risks associated with it and how to properly deal with those. That's kind of what this talk is all about. So it's also important to understand that there are titling issues that I've found over the years that a lot of my clients simply aren't aware of. And even those that are in the real estate world for a long time, they could be realtors. I'm always a little surprised on how little they know about forms of title. Joint tenancy, tenancy by the entirety, community property with right of survivorship, tenants in common. These are various forms of holding title, and every type of form of holding title presents a different type of liability risk associated with it. So I'm sure most of us are familiar with the ideas of holding property in joint tenancy, right? It has a right of survivorship. In other words, two people, typically not spouses here in California, it could be business partners, brother and sister, parent and child. They acquire a piece of property together and they acquire it in joint tenancy. Okay, great. Putting on my estate planning hat, what I'm always worried about is the right of survivorship. So if you happen to be in a business, you both invest in an investment property with your sibling, your brother, and you both invest $100,000. The property then goes up to $2 million, and you're sitting here looking at your balance statement saying, I have a 50% interest ownership in this property. I have $1 million. Well, unbeknownst to you, from an estate planning point of view, you pass away, and next thing you know, your partner, your brother, friend, whomever files an affidavit of death of joint tenant with the recorder's office, and the next thing you know, your estate owns nothing, because the property completely, by operation of law, wound up in the hands of the surviving joint owner. So I have it here in red. I call that the unintended disinheritance. So that's always a shock for some people. Although you may get stuck with 50% of the tax bill, you actually have zero part of the asset. But that's from an estate planning point of view. But what's also important is that the reason why that works is because joint tenancy is ownership in an asset 100% by two or more people. It's not 50-50 in my two people example. It's 100% each enjoying the right of use and enjoyment and possession. They may split the income 50-50 and the liabilities 50-50, but they both own the asset 100%. That's why when one party passes away, the surviving partner gets it 100%. Why? Because they always owned it 100%. And it's because both partners own the asset 100%. When there's a liability to partner number one, that's a joint and several liability of the asset of both of them. In other words, one party gets into a car accident. They can take that entire joint tenancy property, and the innocent co-owner is now on the curb burping and chirping with no property because the way it was held in joint tenancy. So not only is joint tenancy bad from an estate planning point of view, it's also bad from a asset protection point of view. So if you happen to have a property that's owned in joint tenancy, you may want to go back and take a look at that. The proper way of holding property, especially with real estate, is going to be in some form of a limited partnership or an LLC. This way you can still have the percent ownership interests, but this way you also get the limited liability protection of those entities. This presentation is being given in California. We do not have tenancy by the entirety, and it's about half of the other states, mostly on the East Coast. We also have here community property between spouses. So if you acquire a piece of property during the course of marriage, all assets acquired during marriage, except by gift, devise, or bequest, is community property. And as my wife constantly reminds me, that means my half is hers and her half is hers. That's what that basically means. But in reality, what that means is that not only are all the assets acquired during marriage 50-50, well, guess what? All the liabilities that you incur during marriage are community liabilities. Everyone knows about the community asset portion of community property, but they're forgetting about the community liability portion. So I'm sitting here with you guys. It's about 7:45 to 8:00 at night. I'm out here hustling, working for a living. My wife is home. And if I run the red light and hurt someone on the way home, I have a community liability. My wife now just incurred a liability because of my car accident. And as a result, we can lose our house because my community property, my community liability is satisfied by a community property asset. And that doesn't only apply to residences, it applies across the board to everything, rental properties, bank accounts, and other forms of interests. So community property basically makes us jointly and severally liable with our spouses for all of their liabilities. And so hopefully most of you know that you should never enter into a general partnership with somebody. It should be a corporation, it should be a limited partnership, it should be an LLC, but never a general partnership. Why? Because each general partner is, again, 100% liable for the acts and liabilities of the other general partner. So we all know that, and we put ourselves in LLCs or limited partnerships. But when it comes to our marriages and our relationships, we are in a general partnership with our spouses. So if we don't do it in the business world, we certainly shouldn't do it in our more intimate world of our marriage life. So here again, the way that you hold title to assets is very important. Community property, tenants in common is another form of owning ownership. And then just by way of conversation, there's another form here in California that was effective 1106 and has a natural termination date of 1121, which is called a transfer on death deed. It'll be on the scope of today's talk, but something to be interested about. One more thing I also want to point out to you, because I kind of get this a lot when it comes to revocable trust. They say, well, Brad, all my assets, all my rental properties are inside my trust, so I don't have to worry about this creditor protection thing because it's all inside my trust. And I think what they're mistaking is probate protection. Maybe being protected from the unnecessary administrative expenses and time delays of such probate. A handful of years ago, during the Clinton and George Bush years, and maybe not so much, but also during the Obama years, maybe it was estate tax protection. But nowadays, it offers you no asset protection. And the reason why is very simple. If you really go through a very basic exercise, you say, well, if you put your assets in your trust, this is a regular family revocable living trust. You say to yourself, well, who created that trust? And typically you'd say, well, no, we did, husband and wife. Well, who's the trustees of that trust? Well, we are, husband and wife. Who's the lifetime beneficiary of that trust? Well, we are, husband and wife. My kids are contingent, but we're the present beneficiaries. Who has the power to revoke that trust and modify that trust? Well, we do. Who has the power to put assets in the trust? We do. Who has the power to take assets out of the trust? Well, we do. Well, basically what we just demonstrated is that you exercise so much dominion and control over your family trust that there's no difference between it and you from an ownership perspective. So if you get sued, the trust gets sued. The trust gets sued, you get sued. So a revocable living trust is not an asset protection tool. Think about it. If it was, why would anybody have corporations? Why would anybody have limited partnerships? Why would anybody have, pay California $800 for an LLC? Just operate out of your trust. So it tells you by reverse implication that a trust by itself is not an asset protection tool. It is a testamentary asset distributionary tool. It can provide asset protection for your kids, but not so much for you. Now, there are various forms of trusts. There are irrevocable trusts. There are other types of trusts that do offer asset protection, but for most people, the common everyday revocable living trust is not an asset protection tool. I want to make sure I kind of got that communicated, because again, that's one of those demystifying issues. So there you go. An revocable is not an asset protection tool. Okay, I want to address the liability insurance issue because this comes up all the time. And we all have liability insurances in all kinds of shapes and sizes. Auto, umbrella, commercial, EPLI, malpractice, E&O, D&O. First of all, the challenge you have with number one with insurance is, it's sometimes they're about 30 or 40 pages long, double-sided, dual column, 6-point font, right? That's what the policy is. And page one, paragraph one tells you you're covered for the following items. But what's on the remaining 39 pages?
Yeah,
right? All the exclusions, right? Right? All the things that you're not covered for. So we have to deal with these exclusions. Activities on the land, business operations on the land. Hey, I'm running a meth lab. Is it covered? No, it's probably not going to be covered on the property, right? Certain type of dog bites. If you have a dog that's a half Rottweiler, a half pit bull, and his name's Killer, probably going to be excluded from your policy as a bad dog. So you want to see what exclusions are inside there. Another challenge we have with liability insurance is insufficiencies of coverages. And this, I'll give you the fire example that I had about a year or so ago. Well, there quite literally was a fire. Mom died, trying to rescue the daughter died, and then the baby died. The father and the son got out alive. So you had 3 dead people in the rental property, and they wound up getting a $12 million lawsuit for wrongful death. Well, they had a policy for $3 million. And I had a letter from the insurance company saying, hey, listen, it's a covered event. We're going to give you full policy limits, $3 million. Okay, what was the liability? 12. What's the deficiency? 9. That $9 million deficiency doesn't just go away, right? The insurance did its job. It mitigated your first level of liabilities. But what happened to the $9 million? This client in question did not have any estate plan. They had nothing in an LLC. Everything was in their name. They were both 65-year-old retired engineers worth about $8 million, and now they just inherited a $9 million liability. All right. So you have to worry about deficiencies of coverages. So when you have exclusions, you have deficiencies in the coverages, you got to have the next line of defense. The first line of defense worked for you. What happened next? You got to have your next line of defense. You got some limited liability issue to help you work with that. And what are one of those things that they are? It's going to be, in the real estate world, it's going to be an LLC. But before I move on to the LLCs, I want to address one more thing about liability insurance. One of these areas that really kind of gets me. Because the answer simply isn't a matter of, oh, no, the Barth's office, they're going to make you have 3 or 4 different LLCs. Oh, it's going to be more costs and more tax returns and just get more insurance. Well, I already gave you 2 reasons why that may not be sufficient. 1, exclusions. 2, insufficiencies of coverages. Oh, I forgot a 3rd, insurance adjusters, all right, reducing what they are going to cover if it is a covered event. But more importantly is that unlike other forms of asset protection tools, liability insurances are limited in their time and space. Right? They have temporal and spatial limitations. And what I mean by that is that you're only covered during the time that the policy is in force, right? So you have temporal limitations, and then spatial limitations is anything outside the scope of coverage as a result of our exclusions is not covered, right? So your rentals policy may not help you from a car accident. The rental property may not help you when you defame somebody from a defamation claim, or who knows what it's going to be, right? And so they're limited in time and scope. But when you start getting into the asset protection tools that we're using, various forms of corporations, LLCs, limited partnerships, some types of specialized trusts, you're no longer limited in time and space. The insurance may be time and space, but the liability tools, the asset protection tools cover everything you have for the remainder of your lifetime, assuming you keep it in place. Right, that's my second answer to where liability insurance is all that you need. It really isn't. It certainly is a tool that you want to use. You certainly want to have it. You want to dangle it to the creditor, say, take the insurance policy and go away. I'm mitigating my risk. Don't take my house. Don't take my brokerage account. Don't take my retirement assets. Don't take my rental properties away from me. But here's an insurance policy. I'm sorry, it was a mistake. Let's settle it out. You got to have something to dangle. I say you got to dangle the carrot in front of the horse, right? That's what you got to use. So there is a tool. So we want to make sure you have that, but by itself, it's not a plan in and of itself. So LLCs is pretty much the tool that we use. I don't think any of you are surprised with regards to that. But what I think a lot of people aren't familiar with is that LLCs do present protection in two different scenarios. Most people look at LLCs as a limited liability tool. After all, it's called a limited liability company. And so if you look on the screen here, you'll see that an LLC has an owner, which is called a member, not a shareholder, that's corporation's land. An LLC land were called members. And you have a manager, and the manager is the one that's kind of inside the LLC doing the day in and day out operations. And this particular LLC has two properties. Let's say it's got the small little condo and it's got the commercial building. You have a slip and fall in the condo, which by the way is always the case, right? When I have clients that put the fully leveraged out condo along with the $1 million commercial building, where does the slip and fall happen? On the condo and the stairs, right? So now that condo, because it's leveraged out, didn't have enough equity to satisfy the creditor. Because it's inside, the liability occurred inside, the activities of the LLC assets gave rise to the incident of suit. The creditor is inside the box. We call it an internal creditor. And so they start gobbling up all the assets. So the first asset in question wasn't sufficient. So what do? They turn to the next asset, and they will keep on gobbling up your assets inside there until the claim is satisfied. So I'm working with a client right now. He has 15 properties inside one LLC. Listen, that is financial suicide, because it's not only 15 properties. There may be like 30 or 40 doors because there's apartments, there's duplexes. And every single time you have more and more souls on the property, the liability exposure goes up geometrically. And you don't want a problem on property number 5 to adversely affect properties 1, 2, 3, 4, 6, 7, 8, 9, 10, 11, 12, 13, 15. Right? Because once the creditor is inside, they don't sue the condo. Someone slips and falls on the condo, they don't sue the condo. What they do is they sue the owner of the property, which is Condo Holdings LLC. And when you sue the LLC, everything inside the LLC is now at a stay. It's a freeze. You can't start ripping assets out of the LLC. It's called a fraudulent transfer. There's effectively a restraining order put over any transfers as a result of that one slip and fall on the condo. And now every other asset inside there can now be foreclosed on to satisfy the claim. So here you lost both of your investments, but you got limited liability. From an internal point of view, you have limited liability. It did its job. You lost 15 properties, but the remaining deficiency didn't go to you. So along with this, we want to create a multi-entity structure, like these little Russian dolls here. You want to use multiple entities to isolate them and insulate them from each other. And the way that we do this is it all depends on the nature of the properties. I very rarely would ever put a commercial building in with residential. I wouldn't put a duplex in with a single family home gated community. I got slumlord stuff. I got college kids on condos. I got apartment buildings, all kinds of different nature and qualities. I got Section 8 stuff. I got the people that are halfway houses for sex offenders. You don't put that in with your single family home down here in Irvine, California. All right, you keep them separate. So if you have the same liability on the condo in LLC number 1, and now the commercial building is in LLC number 2, now you limited your liability. They can't get to you. And they can't get to the other asset because now it's isolated and insulated. Now, how many LLCs we try to use some type of economy, because California, it is very expensive to have LLCs. We try to bundle them in some way to where it makes sense. I go to risk factors. I told you the nature of the properties, condos, duplexes, fourplexes, commercial buildings, slumlords, whatever. How much equity is inside these things? You look at what's the income that's producing, so you don't trip up the FTVs or gross receipts provisions. So you look at these and you try to map them out to where we're able to create multiple different LLCs to hold the assets, to limit the liability. Now, in the same vein, We talked about the internal activities in the land, but I told you also that not only are the properties a source of potential liability to my clients, well, we solve that with the LLCs. We limit the liability, but now these are also my clients' assets, right? These are my clients' assets. So now if you get sued, it's like me, I'm driving home, God forbid I get into a car accident, and they sue Brad, the individual. Everything that's in Brad's name is able to be taken away in satisfaction of the judgment against me. Well, guess what? I happen to own 2 LLCs, or I own 2 different properties. Not only do I want the liability protection from the tenants, the activities on the land, I also want to protect my investment from the claims of my creditors. I'm the source of liability to my assets, right? So that's why I was telling you earlier that a rental property is both an asset and a liability. It's a liability from a landlord-tenant responsibility, but it's also my asset. And LLCs offering dual protection allow us to be able to both limit our liability and protect our assets. So this is what I'm looking at from it. We call this now an outside claim. We have internal creditors and we have external creditors. And so LLCs are used, again, strategically this is examples of asset protection. Whereas this is an example of liability risk management, okay? And depending upon the equity, the risk factors, et cetera, we think about how to set these up properly. And you guys are all familiar with forming LLCs in California. People set them up in South Dakota, Delaware, Wyoming, Nevada. You heard of these other jurisdictions, and they're using those other jurisdictions for this reason. It helps to buttress the asset protection component. California is a little weak here, especially if it's a community property asset. You and your wife own it 50-50, and the liability is a joint liability. They're able to very easily penetrate those LLCs. So we have to look to some other states that offer us some enhanced asset protection, okay, from that point of view. And so many times we'll create entities, well, here we'll call it Apartment Holdings LLC, Delaware, authorized in California. Townhouse Holdings, Nevada, authorized in California. It has to be in California because the dirt is in California. It has to be in California because you're managing it here from California. You ain't getting away from that. People say, I want to form my LLC in Florida. I don't want to, or Wyoming. I don't want to pay the California tax. Ain't going to happen. If you're doing business in California, you're breathing California air, you're making management decisions, the FTV deems you doing business in California. If it's holding California dirt, for sure, it's doing business in California. You're not getting to get around from that. Also, if the entity gets sued, you want to have standing to go down to the local court to defend yourself. Well, if it's not even registered in California, it doesn't have standing to be represented in a California court. So you got that problem. And if the FTB finds out about it, which they always do because you report it, the K1s on your 1040s, and they to the FTB, and when the FTB finds out about it, they'll say, oh, hey, Bob, you've been doing business in this LLC for the past 8 years, and you haven't been paying your California $800 per year. They go back and get you for all past years and penalties, and sometimes they'll slap on an extra $2,000 for a good measure. So you're better off just filing it in California like you're supposed to, and just it's deductible against the income. And if you ain't cash flowing $800 a year on your LLC, you're in the wrong line of business. Okay, so it's okay. Just got to get it filed in California. It's the proper thing to do. Now, when it comes to residences, here again, it's one of those unique, intimate assets. It also deals with real estate. Again, you're not likely to sue you, but someone's going to want to sue you. I'm sorry, you're not going to sue yourself, but someone's going to sue you and want to take your residence. So California has a pretty crummy homestead exemption that if you're single, it's $75,000. If you're married, it's only $100,000. If you're over 65 or living with a disabled, I think it's $125,000. And so when someone sues you and they go to have a judicial foreclosure on your house to find a source of funds to satisfy the creditor, they don't really want the dirt itself. They want the value that the dirt represents. And the problem is, again, because California has such a small homestead exemption, the homestead really isn't there to protect us. Unlike our good and dear friend O.J. Simpson, who was able to purchase a multi-million-dollar property in Florida, well, Florida has an unlimited homestead exemption. That's great. Texas, unlimited. Other states, I think it's Nevada, I think it's $350,000 or $550,000. And other, they have much better homestead exemptions. In California, married couple, only $100,000. So not by itself very good. So you got to find something to do besides just the homestead exemption. So one of the things that we look to is, again, going back to the idea that the creditor doesn't really want the dirt. They want the value that the dirt represents. Well, what if you use debt? Everyone thinks about, let me pay down my mortgage, pay down my mortgage, pay down my mortgage. I want to be debt free. As a matter of fact, I had a call, I think it was my 2 o'clock call today. They were very, very happy that they paid off their home at $700,000 and they had no debt on it. Problem is, he got into a car accident, and then the lawyer who wasn't going to said, we did some research on you. In other words, they went in the public records, saw the guy's name on public records, saw a house that had equity of $700,000, and now they're going after him saying, oh, now you got money. We're not going to settle for the $100,000 insurance policy. We want more. We want like $500,000. We know you got it because your property is readily available. And I told them, in my world, actually paying your house down is a bad thing. You want to have debt on the house. You only got $100,000 in homestead. If you have a first with Wells Fargo, and then you got maybe a second home line of equity line, and you say your house is $1 million, you got the homestead exemption that leaves you a $900,000 equity corridor. You owe Wells Fargo $500,000. That's only $400,000. You go get a HELOC for $200,000. That leaves a $200,000 equity corridor. Well, you're not going to get $1 million in a judicial fire sale. You can easily take 10, 15, 20% on a fire sale discount. You got cost of sale. And when all that's said and done, a court will not kick you out of your house unless there's a material benefit to the creditor. And getting $10 out of you after you pay off the first, the second, and the homestead, if there's no material benefit, your house is protected. Why? Because you use debt, right? Because there's no value there. As lawyers, we don't sue people for sport. We want to get something out of it at the end of the day. But if you simply equity strip, you take all the equity out of the property, you need to put that someplace safe. A different conversation, a different seminar, right? But the important thing is we try to find legitimate sources of debt. You owe people money, you borrowed money, you lent money to the business let you got long-term leases. We want to find some way to put a legitimate lien against that property so that it's protected from the claims of creditors, just because it's not very attractive because it's full of debt. One thing I get all the time also is say, hey, Brad, you just got done rambling on about the benefits of LLCs. Why can't I put my house in an LLC? Well, because what happens here is you change the nature of your property from residential to investment. And I'm sure all of us are aware that when you have a residence, the government likes people buying houses. They give us tax benefits. They give us interest write-offs on our mortgage. Although it's capped, you get to write off your interest mortgage. You get a capital gain exclusion on sale, $250,000 per person, $500,000 married. You do get a small homestead exemption here in California. You get credits for putting solar panels on your personal residence. This is all to encourage people to buy a residence. If you take that property, your residence, and you put it into an LLC, it's no longer personally owned. You change the nature from residential to investment. And as a result, you lose the $250,000 cap gain exclusion. You lose the mortgage interest deduction, and you lose the homestead exemption. These are all possibilities. There are some ways to do this correctly, but this is basically the general idea. And you don't like pay rent to yourself. It's kind of weird to live in your own home. It's just weird. It doesn't really quite work as well as most people think. So you got to find some other way of doing this. And one such way is we use basically some various forms of trusts. This one is a residential privacy holdings trusts, where you're kind of combining the use of a land trust along with an asset protected LLC. There's no tax benefits here because it's still what's called a grantor trust. still qualifies for all the tax benefits, still qualifies for Prop 13 exclusions, et cetera, but we were able to kind of use a hybrid of a trust and an LLC to still deem it residential, although the bundle of rights, the beneficial interest, is tucked away inside an LLC. Another thing that we also use for our more of our higher net worth clients are things that are called qualified personal residence trusts. This is more of an estate tax minimization tool. Kind of came out of fad for a while because under the Trump administration, our exemptions are so high that the need to do estate tax planning to get your house out of your taxable state isn't as much of a pressing issue as it used to be maybe 3, 4, 5 years ago. But it's still a very relevant tool because we don't know what's going to happen with the next administration, whether it be in 2 years or be in 6 years. We just don't know. So it's still a very viable tool because although we're enjoying a very high estate tax and gift tax exemption today, that may not be the case tomorrow. Now, it could go from 11 million back down to 3.5 million, or 11 million down to 1 million. And these were the numbers that were presented in the past election with the various candidates and their tax platforms. So the use of a QPER, a qualified personal residence trust, is an amazing asset protection tool. And you get a twofer, you get a second bite. It's also a great estate planning tool as well to minimize your taxes. Again, those are two wonderful things that are designed specifically for residences. Let's take a look here. Yeah, so within a residence, this is primarily an estate planning tool. You still retain the full power to buy, sell, refinance, et cetera, and you still enjoy all the benefits of what's called a grantor trust status on your reportings for your properties. So I just want to kind of wrap it up here and kind of open it up for questions in the last few minutes here. But that's basically a real shotgun approach to some of the very basic tools and techniques that we use for real property owners, both from an investment perspective as well as a more intimate. It could be our residences, it could be a vacation home that's ours. And as I mentioned, I'll just repeat this again, that residential real estate is a wonderful investment for a myriad of reasons, but you just have to appreciate that it does come with some liabilities. So you go into this thing with eyes wide open, you have full knowledge and appreciation that there is some liabilities associated with it, no problem. You just have to kind of wrap some of those liabilities to limit the liability to you, but also to protect the asset if so warranted. So with that, I guess I'll turn it back over to Paul to see if he has any questions or comments. I know I kind of rattled off here, so.
Yeah, please. Great presentation, by the way, Brad. We haven't met. I can't even see me. My name's Bobby Elam. I'm an attorney, so loved your presentation.
Great, thank you.
I wanted to ask you, especially you ended with the residential, your home.
Right.
Put it in an LLC or not. I've had several people come at me, and it's really fascinating to hear this line of thinking, the idea of there's so many internet resources right now to find out who you are, that some people are thinking of just hiding assets just to disappear. I mean, I've heard politically people be sidelined, especially on the left, for even owning a condo. That for some reason, if they have wealth, they can't speak to issues of homelessness or fairness or whatever. And so all I'm getting at is, are there mechanisms to have greater privacy?
Right. Okay. Great. All right. So the first thing I'll comment on, and this is one of my favorite lines, is that the internet, not only is it the information superhighway, it's all the information wasteland, right? So you got to kind of take what you get, again, we find out what you're looking at from a source perspective. Okay, now from a privacy point of view, and this was the example that I gave the client I spoke to again just today on this $700,000 property that was paid off, that there's nothing more public than real estate, right? And I'm sure all of you in this industry know that. And so one of the tools that we use, and again, I pointed it out, was that Residential Privacy Shield Trust. One of the very basic things I do with my clients is don't look like a rich guy, And if you type in someone's name in the corporation wiki, you'll see an organic population of all the different entities that your name shows up. Or you put in someone's name in the public records and you'll see the title search shows all the real estate assets that are associated with your name. So one of the first things you want to do is go incognito. You want to get your name off. In other words, you hold things in nominee. I am the nominee trustee for hundreds of my clients. I've been doing this for 21 years. Hundreds of my clients. You look them up, you're not going to find their name. You look up the property, you're not going to find their name. I myself am a professional trustee for my clients. I deal with kids that are strung out and drug addicts and girlfriends and crazy. I want my money now, blah, blah, blah. You're not going to find my house on public records either. I don't want them showing up at my house at 3 a.m. and putting a gun in my face for risky business. So you want to go incognito. There is a way of doing that. You just have to put the extra step in there to be able to accomplish that, right? So there is a way of doing it. The fact that you're coupling it up with an attorney gives you a double layer. You got the structures that give you the privacy, but now you're also buttressing that with an attorney-client communication privilege as far as disclosure of documents. But for an affidavit or some type of subpoena, they're not going to get any information out of us, right? So I hope that answers your question.
Yes, it does. Thank you.
Okay.
Yeah, this is very basic. You may have covered it. So in California, if you have 4, 5, 6 properties, and now we understand that you don't want to put 4 or 5, 6 properties in one LLC.
Right.
So are you advocating 6 LLCs then, or 6 properties?
In a perfect world, the answer would be yes, but I don't want to asset protect you into the poorhouse either, right? So there's got to be, like I said, there's got to be economics behind it. That's why it's okay. It's not, that's where the art of what I do is really kind of, and the experience really kind of plays out, because the science is easy, LLC, okay? Now the art is how do you combine them? You're looking at risk factors, as I mentioned, the nature of the property, risk factors, number of occupants, income, equity, location. And if you have 6, if we can get away with 4 and 2, maybe 2, 2 and 2, maybe even 5 and 1, because the 5 have no value, right? No value and value. So why would you spend all this money in making 6 entities when it doesn't have any, the economics don't work out, right? It needs to make sense. So that's kind of how we deal with that, right? So in a perfect world, if we lived in a place like, I don't know, like Wyoming, where it's $50, I mean, put your kids in an LLC. You know what I'm saying? We're in California, so we have to be a little bit more economical with our decision making.
Okay. Another question here, yeah.
Yeah.
I saw your example about the LLC in California and then in Nevada. I have 2 questions. Can you explain how that works and the benefit of doing that? And then in addition, I understand if you have an LLC and you want to put properties into an LLC that have different ownership percentages, and you do that, you're subject to reassessment from a property tax standpoint. Can you tell me if that's accurate?
Okay, sure. So one is the multi-jurisdictional issue, and the second one is Prop 13s with different ownership. Is that correct?
Yes.
Okay, so the first one on the multi-jurisdictional. So using the example that you said, Nevada, all right, you create a Nevada LLC authorized in California. First of all, I hope I made it clear that you are doing business in California. 2 reasons. Well, one, because you're here in California and the property is here. So from the internal affairs, you're talking about a California LLC, not a problem. But California doesn't really provide protections from the outside grab. We're looking for, it's called exclusive charging order jurisdictions. And California doesn't. California allows for judicial foreclosure. We don't like the word judicial foreclosure when it comes to our LLCs. So you want to go to a jurisdiction that says that charging order is the exclusive remedy and a judge may not foreclose. So you want those extra little subordinate clauses that basically limit what a judge can do. So you go to those other jurisdictions. But again, remember, we're talking about outside versus inside liability issues. Now to your point, if someone sues you in California, the tort action is going to be here in California, landlord tenant, no problem. You get into a car accident and they sue you and they want to grab your LLC. Now the jurisdiction of that ownership interest is going to govern the remedy. And when you register it in California, our corporations code even says if the entity is registered in another state and it's registered here in California, we will respect the jurisdiction of the other state for its remedy. And so that's where Nevada law comes into the outside exclusive charging order protections. And now we've also created a conflicts of law issue. So you have a California court saying, hey, wait a second, we have a strong urge to want to enforce our judgments, a strong interest. And Nevada says, wait a second, but we also have a strong interest of enforcing our protective jurisdiction clauses of our LLCs. So now you have a conflicts of law issue. And all that muddiness in the water works to our advantage because a lot of lawyers simply don't know what to do. And remember, what am I trying to do here? What am I trying to get you at? A position of settlement. And if we make it more difficult for them because of the conflicts of law issues, the protective jurisdictions of these foreign jurisdictions, that works to what we're trying to accomplish. All right, so that's how it works. All right, now the second point on the Prop 13 issue. There are a handful of exemptions of Prop 13. Now, the one that you were talking about, a disproportionate ownership, will trigger a Prop 13 reassessment to the extent that the original owner is not the same as the new owner. So if you have the property owned by you 100%, and then you give it to you, your sister, and your good friend, now you have a single owner, now you have an LLC, a third. Well, your third didn't change. That ownership's the same. But the other 2/3 did change. So you'll have a 2/3 proportionate reassessment. All right? So what we try to do is we try to make sure it's apples to apples beforehand. So if you owned it by yourself beforehand, you form an LLC that's owned by you, and you transfer it in. So now you have a proportionate ownership before and after the transaction. Now, once it's in the LLC, if you want to give 2/3 away to your friends, different story. Different issues. Let's not go over 50%. That itself would cause a reassessment. But you want to be careful in how you do that, all right? And besides, in the example I just gave you, which I think is relevant to your question, not only do you have a reassessment issue, but you also have a gift tax issue because you gave the property away to the LLC new owners. Oh, and then one last thing. Banks get a little upset about that, by the way. When you simply take your LLC, your property, let's say it's husband and wife, and you put it into an LLC that's owned by you and your husband and wife, there really isn't a change of ownership. You see, it's husband and wife before 50-50, it's husband and wife after 50-50. The banks get it. It's not really a true change of ownership. What you did is you changed how you held title. But if all of a sudden you go husband and wife to LLC, husband and wife, kid, friend, nephew, and the countryman, okay, the bank didn't underwrite your kids, your nephew, or your countrymen. You're literally giving their collateral away. And banks exercise due on sale clauses when you give their collateral away, right? So you got gift issues, you got due on sale clause issues, and tax issues, right? So just, as we say, don't do this, don't try this at home, kids, right? So, you want to make sure you just do it. It's no problem. Just do it correctly. That's all.
Another question.
Yeah.
But with respect to the reassessment of the property taxes, in your experience, is it best to be proactive for the county first and say this is what I'm doing, rather than do it and then they reassess you and then you have to go fight the fight?
Yeah. Ordinarily, it's as I think I tell my kids or myself, it's better to ask. It's easier to ask for forgiveness than it is to ask for permission. Right? Is that how the saying goes? Right? If you ask a bank, they're going to say no. If you ask the assessor, they're going to say no. So, and besides, the assessor won't even give you an answer because until you record a deed, you have to have an instrument number. And until you get that recorded instrument number, the assessor's office has nothing to link the transfer to. So there's no need to, to do any trial balloons here. You just do the transaction to fit within the various exclusions to Prop 13, And if you get a notice of reassessment, which our clients get all the time, you just have to substantiate the claim that you're making, right? So there's no problem with it.
Thank you. Another question over here.
Years ago, doctors, lawyers, plumbers, they used to have the ink after their name, incorporated.
Yeah.
Less of that, but you see all these LLCs. So what is the difference? What has changed?
Yeah, so she's asking that. She brought the example of doctors, lawyers, professionals used to have inks, corporations. Now you see a lot more LLCs. What's the difference?
Yeah, well, you're not going to see LLCs behind the name of doctors, I can tell you that, because you cannot beat LLCs here in California. You're not going to find them behind the names of lawyers. You're not going to find the LLC behind the name of the person that cuts your hair, right? Because any licensed business in California, our Business and Professions Code prohibits you from being an LLC because it's simply too protective. So you are going to see Inc., or like with my firm, an LLP, Limited Liability Partnership. But I think the gist of your question goes back to the different types of entities. Inc. stands for corporation. LLC stands for limited liability company. LP stands for limited partnership. LLP, limited liability partnership. So those initials at the end of the company is communicating to you what the form of the entity is. And corporations and LLCs and limited partnerships are completely different. They're different from a tax perspective. They're different from a legal perspective. And so when you choose what form of entity, you should do it with the advisement of both your tax professional and your legal professional, right? But that's what those letters are at the back of someone's name. It's one saying it's a corporation versus an LLC or a limited partnership. And you got to use those. You want to broadcast to the world that you're not dealing with me, an individual, you're dealing with my entity. Therefore, if you have a liability, your liability is the entity's liability, not my liability. You want to make sure you use those abbreviations in your title: signature president, Brad partner, lawyer, you manager. You want to use those titles so you're not causing any confusion in the marketplace as to who they are dealing with. It's very important. Good question.
Brad, I think we're good here. Yeah, thank you so much.
Yep. Good. Thank you. Well, I guess I'll just turn it over to Paul. Paul, I think you'll kind of wrap it up for us.
Yeah. You
Okay.
got 4 kids and a wife waiting for you at home.
Yes, I do. Yes, I do.
All
Okay.
right. Thank you.
Okay. Thanks, you all. Thank you for your attention. Bye-bye.
Hi, this is Paul, and thanks so much for jumping on the presentation. Hope you enjoyed it. I want to get you connected to our complimentary planning assessment, get you one-on-one with the team for input on your own situation. And this is how you do it. You text Guard Assets to that number on the screen, and you'll be able to sign up and pick a time to get one-on-one. And any issue is perfect for this complimentary assessment, whether it's asset protection, estate planning, business planning, whether it's a small issue, a huge issue, or anything in between. It doesn't matter. We're happy to give you input. You can throw the kitchen sink with questions at us. We're going to get into the weeds with you. And what comes out of this session is our blueprint for you of observations and recommendations about how to plug up any holes in your planning, new opportunities to have really great planning, and just to get you organized, updated, and protected. So text Guard Assets to that number and really look forward to getting you some input. Thanks so much.